Hi, this is Steve Cinelli. We're reporting here from the Crowd Caucus. Welcome back from our Sunday show. We're pleased this afternoon to have Kendall Almerico, the CEO of FundHub.biz, with us, one of the leading attorneys and recognized crowdfunding experts, and certainly an expert in the area of the Jobs Act. Welcome, Kendall. Thanks for joining us.
Well, thanks for having me, Steve. And just as it always is with Sydney, you butchered my name. It's Almerico, but I'm used to it because Sydney literally cannot say my name. Every time he introduces me at one of his events, it's like, here's Kendall, and then he says some word that sounds like "am a margarita" or something. So it's okay. I'll correct it. It's Almerico. But thanks for having me on.
Well, let's just go by Kendall, okay?
That'll work. That'll work. I like that. I like that.
Yeah, good. Anyway, you know, it's been some time since the passing of the Jobs Act, which you're quite familiar. Maybe you can share a little bit with us and our audience as to what went right, what went wrong, for those things that have not materialized as we anticipated. You know, one of which, of course, is Title III. What's the holdup?
Well, the holdup on Title III, and for those who aren't familiar with Title III is the part of the Jobs Act that legalizes the equity crowdfunding, the actual thing that we all want, those of us in the crowdfunding world, where you will be able to, with your business, go online to a funding portal, raise up to $1 million from anyone in the general public, just like you could go on a Kickstarter or Indiegogo and pledge money. You'll be able to do that and sell equity in your business. That's Title III of the Jobs Act, and when the Jobs Act was passed in April of 2012, over 2 years ago, the act itself, the law, is 9 pages long, and it said this needs to be put into place. You know, the SEC has to put rules into place so that this law will be live in basically by January 1st, 2013. It's now June 2014, and we still don't have the law ready because the SEC didn't meet their deadline. And then they passed some rules to send out to public comment last year in October, and they set out 585 pages of rules for a 9-page law. Some of which are ridiculous, some of which are very good, and don't get me wrong, it's when you ask the SEC to change 80 years of law in one fell swoop, you're going to have some problems, and I understand that they had to do their job, but the problem is it was last October. We're pushing up on a year now since those rules were put out to public comment, and they're still not in effect, which basically means nobody can use equity crowdfunding Title III yet, even though the law was passed more than 2 years ago. It's a shame. It's very difficult, and there's a lot of things that need to be fixed with that law, Steve.
Yeah, Kendall, educate me for a little bit, because you're a practicing attorney in the securities world. Certainly, I've had my own experience in crowdfunding. I was a founder of a company back in 1999 that actually took the Reg D private placement process into the digital world, namely Off-Road Capital, and so we've dealt with the Reg D exemption and so on. Certainly Title III is a subset of Reg D in terms of providing unregistered securities for the investing consumption. The question I have is, there's other markets that allow the John Q. publics, as I call them, the ability to invest in early stage, even pre-revenue companies. You know, you look at the over-the-counter market, the QB market that the OTC runs, which are venture-backed companies. These are public companies anybody can invest in. Many of which are pre-revenue. You've got the AIM market over in the UK. You have the TSX, the venture exchange up in Toronto. Why is it there this bifurcation or almost antithetical approach to you can invest in pre-revenue companies publicly, that are publicly listed, though the market risk, the volatility, and everything else would, in my view, seem to be more risky than investing in a private company that doesn't have significant aftermarket trading and thereby volatility. Can you compare and contrast the sort of the aspects or the perspective that the SEC has? In one market, yeah, you can do it as John Q. Public, and Title III, they have this apprehension.
Well, remember, the SEC has been enforcing the same laws since 1933. So you have laws that have been in effect literally for 8 decades that have been gone through the court system, gone through the arbitration system, gone through the ringer. Lawyers have interpreted things. Congress has fixed things. They're set in their ways up until 2012. So the OTC markets, the pink sheets, the bulletin boards, all of those things that were out there before are all pretty much, I mean, listen, they're highly volatile. They're not great investments in many cases, but they all follow along the same theory of a stock that's listed on the New York Stock Exchange. There are disclosure requirements, registration requirements, all kinds of things that the SEC governs in every one of those situations. So the companies that are listed, the companies that are registered, are totally different than the companies that are going through Regulation D, as you pointed out, Steve, or through Title III of the crowdfunding world, where you're basically talking about anyone who wants to start a company can go out, fill out a number of forms that someone can give them, but none of those have to do with the SEC. You only have to file one form with the SEC when you do this. It's a very simple form that they've created called Form C, if the laws go through the way that they're proposed. So there's no registration process, no prospectus, no due diligence that goes through the SEC. All that's being done outside of the SEC. So when the SEC looks at a pink sheet company or one of the OTC companies and they say, hey, at least they have requirements they have to do that are, we're familiar with. Now we've been given a law that says you have to do something totally different. You're going to let somebody go online, potentially put a video up, describe their company, describe their financial statements, and then we're going to let people click on a button and use their credit card to buy stock in that company. That's a totally different world for the SEC. I'm not saying it's a worse world. I'm not saying it's a world that's not manageable, but they had to look at it and say, oh my God, this is not what we've done before. How do we make that work? How do we protect investors? How do we protect the businesses from, unscrupulous people? It's a tough challenge for them. I think they went way overboard. But what the problem is, they're trying to create regulations for something they don't regulate, and that's where it gets to be incredibly complicated.
But isn't it true that some of the companies that do have public listings, and I'm looking at the thinly traded
Sure.
OTC stocks, there are provisions where certain companies aren't subject to the 34 Act. They don't have to report. They still have a public listing. They still have access to all investors, accredited and non-accredited investors. And it would just seem, again, as I said before, inconsistent because there is no limitation on investing in these nascent, skeletal companies on the public exchanges where everybody could invest their life savings and be subject to high degrees of volatility and lose more just because of the trading aspects as opposed to the investing aspects.
Sure.
It just seems that there's one side of the house that the SEC may not be listening to the other side of the house.
Tell me about it. No, you're absolutely right. And if you look within the Jobs Act itself, you have there's several different titles in there. Title II, which deals with Regulation D and deals with 506C, which is very similar to what you were doing before. They have rules that are in place for those that don't conform with the rules for the Title III. And then you've got Title IV, which is another quagmire. It could be the greatest thing in the world if it gets passed the way that the SEC's rules propose. But when you look at the three together, it's like you have three completely different Congresses and three completely different governing bodies defining the exact same terms sometimes. And it's crazy. I mean, it's absolutely insane. This is the same law being interpreted three different ways totally inconsistently. So I think what probably happened, if I had to guess, you probably had different committees within the SEC that reviewed these things, and they didn't really talk to each other. And it's just like you said, the people on the left weren't talking to the people on the right, and you end up with this crazy mishmash of laws that doesn't conform within itself and doesn't conform to what's already out there.
Yeah, the one other observation, and when we did the earlier company, we did a lot of studying of different capital market systems globally. We had set up sister markets in various places in Asia and so on. The U.S. securities market, supported by the SEC back in, as you say, 80 years ago, 90 years ago, has been the emulate for many of the securities markets globally. even though ours is somewhat antiquated and it takes a while to muddle through, so many of the laws and regulations. But it seems like other countries, like the Italys of the world, the UKs, they're very rapid in terms of developing some sort of crowdfunding legislation to get the game started. What are we missing? What are we missing here? Is it form over function?
Yeah, another great example is Canada. I mean, just a couple of months ago, Canada passed their in their provinces, and they've got a mess. I mean, they got to deal with all the different provinces that all have different rules. They passed, in essence, uniform laws throughout the provinces. They're not exactly the same, but they're going to be. It's very likely you're going to have equity crowdfunding in Canada before you do in the United States, and they literally just put their rules out 2 months ago. The problem is the speed of the process, and I think internally. I know internally before Mary Jo White took over the SEC, there was no love for crowdfunding at the top of the SEC. It was not a priority. It was never going to get through under the former management. Now, Mary Jo White has come forward when she was first sworn in saying this is a priority, and she did get the rules out relatively quickly. But now here again, it's almost a year since the rules came out, and where are we? I don't know. It's the government moves slowly, and what I think is interesting, Steve, is you already have, I mean, think about the process of this. You have the legislature, so you have to get something to the legislature. You have to get it through the House of Representatives. You have to get it through the Senate. You have to get them to agree on the law. Then you have to get the president to sign it. Well, that was done in a remarkably fast fashion here to get this law through. It wasn't what everyone wanted it to be, but it's a law. Then it goes to the regulatory body to create the rules to let you use this law. So you have this long process that's going on. Now, while it's still there, we don't even have the law enacted yet. We've got the SEC, the regulatory body, trying to figure out what to do with it. You've already got new bills being introduced into Congress to fix the Jobs Act, to fix Title III, to create Jobs Act 2.0 that'll fix the problems. The SEC hasn't even passed into law yet. That just shows you how crazy our system is. They're trying to fix a law that hasn't even been put into effect yet with something that probably will create a whole new set of circumstances if it gets passed. That means we'll have another 2 years waiting for SEC to create rules. It's insane. It's absolutely crazy the way things work in our system.
Taking it one step beyond the Title III morass, one of the other subject matters that has come up under Reg D is the redefinition of accredited investor.
Right.
It's been a subject matter for many, many years, as we talked about on our show on Sunday. The original Reg D was instituted back in 1933 with the passage of the Securities Act, but it wasn't defined. In terms of numbers weren't assigned to what makes an accredited investor or not. It wasn't until 1982 that those definitions, and for the most, where the net worth requirement, the income requirement, it's been discussed, ad nauseum in terms of should those levels still be appropriate or should they be raised?
Right.
What's your view on that?
Well, I have two views on that, Steve. Number one, there is a lot of talk about raising the limit, which would, some of the numbers I've seen would cut the number of accredited investors by 40 to 50% that would be available to fund, new ventures. I mean, if they raise the limits to a certain level, you're talking about cutting out a lot of potential investors. The second problem is 9% of there's only 9% of the accredited investors out there who actually invest. So if you take that tiny percentage of the big population and then you cut that in half, you're really going to hurt funding for small businesses. I think it's a bad idea to raise the limit. Secondarily, this is what, the best example I can possibly get to put it into real terms for people. There's this assumption that because someone has money or makes a lot of money that they're sophisticated. I think you can probably look at some of the rappers out there and some of the football players out there and some of the people that are, in the entertainment world out there and some of the stupid things they say, and you realize just because you make a lot of money doesn't make you sophisticated or a very good investor. It just means you make a lot of money. So tying the ability to invest into an amount of money is a ridiculous thing to begin with. Here's the best example of that. Bernie Madoff. Bernie Madoff took hundreds of millions of dollars from all accredited investors, all people with a lot of money. everyone, I shouldn't say all of them, but a grand majority of the people that he put into his Ponzi scheme were very wealthy and were all accredited investors, and they all got duped by someone in a Ponzi scheme. It just goes to show you the level of sophistication has nothing to do with investing, and the level of money you make has nothing to do with your ability to invest properly. So my personal feeling is leave the limits where they're at. It makes no sense to have limits to begin with, but it is what it is.
I would let's see. I think we lost the feed here. I would submit that the definition, or even the application of a definition of accredited investor, is passé. Is it really necessary any longer? The fact of the matter, if you look at the history, I'm sure you know the history. It was a means by which small companies, it was instituted so small companies could raise money without going through a heavily papered compliance process to raise money through those that had the means by which to lose the capital. And so the thought was, this is a nice buffer. It gets monies into small business, and it changed the disclosure requirements for such small businesses. We're in the world of the internet. We're moving capital formation online. Information is readily available in every shape and form. And as we talked about before, there's other ways that so-called non-accredited investors, those that don't have the same means as an accredited, can gain access to investment opportunities which are fraught with risk. At the same time, there's no limitation we're placing on a individual who's not accredited to go to Las Vegas and spend his life savings. And I find it somewhat inconsistent, and maybe it's a period of time, given that information is now readily available. The level of inquiry certainly placed on the investor to do their own homework and whatnot. Should the whole subject matter of accredited investors be put aside?
My personal feeling is it should. My second personal feeling on this matter is there should be some limitations on the amount people can invest if you're going to get rid of the accredited investor standard. Now, I say that. I'm one of those proponents of get the government out of the way and let people do what they want to do. But I also see what happens to people. And you bring up the casino example, and there's nothing to me sadder than walking into a casino. I'm in Las Vegas on speaking at some convention there, and I walk through the lobby and I see some very nice looking old woman sitting there with her oxygen tank, on a slot machine for 8 hours, literally probably pumping every dollar she has into that slot machine. And I almost wish that casinos could have, you check in and they say you're only allowed to gamble $100. Mm-hmm. They don't do that to casinos. They don't stop people from buying as many lottery tickets as they want. They don't stop people from going to the OTC or bulletin boards or pink sheets and giving their life savings away. But I really do think that it makes sense to protect the unsophisticated people in some way. In some way. And that's why I don't have a problem with the Jobs Act provision that limited the amount of investment. I know many people do, and many people say, well, you shouldn't tell people what they can spend and what they can't. I think it's okay. I think that's a fair government regulation to say, if you only make $100,000 a year, you shouldn't be gambling. You shouldn't be investing more than $2,000 in a startup business. But then I also think they should be saying you can't go to a casino without more than $2,000. They're not going to ever do that. And the problem is that they don't comport, Steve. They don't make any sense together. But the government is there to protect people and help people to make sure that they don't do stupid things. It's just, where do you draw that line? And in your example, getting rid of the accredited investor requirement, I think would be a great idea. But I do think if they did that, they would really have to make sure they have some protections in place for people to not spend their life savings on something that, some snake oil salesman calls them up on the phone and, like the Wolf of Wall Street, and sells them a startup business is in a garage somewhere that doesn't exist. So having some protections in place to protect people from their own stupidity is unnecessarily a problem, and unnecessarily something government has to do sometimes. So I think that probably is the way I would sum it up if I were the king of the world, which I'm not.
Yeah, maybe in time. I was thinking back about the whole regulatory and the SEC role and why it was put in place back in the as a result of the Depression and the in the Hoover administration and whatnot. I don't believe that the their mandate was necessarily to certainly to protect investors, but
no, I don't think it was.
Do so in a manner that make sure that companies disclose sufficient information so someone can make a rational decision. Your point's well taken, that just because you have a big bank account doesn't mean that you can comprehend what that disclosed information is. As you, I'm sure, have recited in some of your speeches and conference, is that there's a high level of financial illiteracy in the United States.
Sure.
And that's a problem. So no matter how much you disclose, is the reader actually comprehending what he's reading and can make an informed decision?
Right.
And again, the SEC, both in the 33 and the 34 Act, it's about disclosure.
Right.
Keep investors informed about a decision, and then keeping the market informed about how that company does. But it still implies that the SEC's role is to make sure that disclosure is made. But are they overstepping their bounds to say, well, this person can comprehend this versus this person not being able to comprehend this?
Absolutely. There's no way they know if someone can comprehend it or can't comprehend it. That's what I like about the way one of the things I like about the way Title III was written is that they require you to disclose educational materials as well as a business plan. Yeah. So you not only have to go out and say, this is what I'm doing in my business, this is how I'm going to run the business and raise money and how it's going to be successful, but you also have to provide as a funding portal educational materials to people. I like that. I think that's a good rule. I know it's the government stepping in and saying something, but you know what? That's a good thing. Help people learn. I mean, that's one of the things we're doing at FundHub. When there's a million things we're doing at FundHub, but one part of it is me attempting to make sure that I keep passing along this knowledge to people about how to do investments. And I looked long and hard on the internet trying to find any place where you could literally go in and say, I want to start a business. What are all the different ways that I can raise money? And it doesn't exist. So we're building, when we launch the official site in a couple weeks, you're going to have a little quiz you can take that says, I need to raise X number of dollars. This is my type of business. This is what I'm trying to do. And it's going to tell you literally maybe 15 or 20 different ways you can raise the money, literally from, hey, go to your savings account and pull it out, all the way to, hey, you're going to do a public offering, and explaining what those things are so people can, and not in terms that the SEC wrote, but in terms that anyone can understand. That type of educational information, I think Sydney probably has heard me say this a million times when I speak, our job as people in the crowdfunding world is not just to make this world happen, but our job is to get out there and educate people and teach them what's going on. That's why I love doing these things, because if I 10 people now come out of this and say, okay, I get a little bit more about that, now I'm willing to invest in this world, but I'm going to do it with my eyes open. I'm going to read those educational materials. I'm going to learn how to read a financial statement. That's what I think this is all about, is making sure people learn how to do this so they don't get taken.
Yeah, one of the other observations, and I've looked at the disclosure of many of the platforms, just sort of comparing and contrasting, and it's much like in a lot of respects, the crowdfunding platforms are really digital investment banks.
Yes.
They're serving in an agency function. They're raising either actively or passively on behalf of a company through their particular platform and their audience, their investor community, capital for these companies. One of the things I remember in the the analog days of private placements is that every banking firm used a different format, used a different style of book, disclose things in a different way, and sometimes it became somewhat challenging to compare and contrast, because what you see in one deal is looking differently, not just because of the company or the industry, but it's the way information is portrayed. And that's the thing that I'm concerned with out in the crowd space, even for the accredited investor sites, is that the way they display information is fairly inconsistent from platform to platform. That's something that really has not been addressed.
Right.
I know that there's effort, the SEC's original effort was to standardize disclosure, so there's a level of comparability. You've got other government agencies outside of this, like the Consumer Financial Protection Bureau, trying to standardize, consumer finance documentation, so you understand that, so it's not overly legal or legalese. What do you say to standards? What do you say to, education? I absolutely underscore. I'm completely in your camp, which is definitely needed. But in order to do that, rather than reading, a different language every deal, what do you say to standards?
I would love if the SEC would come out and say, this is what you need to disclose. This is what's good, this is what's bad, this is what we need to see, this is what we don't need to see. Here's a form you fill out. I mean, they have forms. They have Form D when you do a Regulation D raise that you have to fill out and send to them, and it gives a certain standardized amount of information. But it's very, very important that people disclose everything, but they need to have some standards. There are none. There never have been. As you know, Steve, I mean, there are people, I'm in the world that creates private placement memoranda for people, in my law practice, and we'll be doing it on FundHub for people, but you don't even have to give a private placement memoranda in most of the things that are done in the private world. People think you do. There's no law that says you do. None whatsoever. You can literally
You got to show a balance sheet, and that's about it.
Yeah, I mean, it's amazing, but people do it because it gives all the disclosures and gives all the danger signs, and it tells a little bit about what's going on. But the bottom line is people don't realize that. They think, oh, you have to have one. I got to go pay a law firm $100,000 to create a private placement memo so I can go raise $50 million. It's ridiculous. And the fact is you don't have to do it. If you actually disclose all that information, and, from a lawyer's perspective, you want it to be in writing. But if it's on the website and someone has to read it and check off the boxes and say, I read this, I read this, I read this, I know that that's there. If someone came up with a great, I think what we're going to see, and this is one of my predictions in not only the 506C world, the Title II world, but also the Title III world, I think you're going to see someone come out with a funding portal that does a great job of that really hits it on the head, and then you're going to see everyone copying them, and then you're going to see the SEC say, that's how you do it. But no one's done it yet. I haven't seen it yet. I've been looking for it too.
Well, Kendall, stay tuned. That is coming. That is coming.
Good.
And with that, we've got to wrap up here. Thank you, Kendall, for taking the time, and enjoyed your perspective and your insights, and hopefully we can pull you back shortly into the show as the Jobs Act unveils and chapters are created and turned and whatnot. But thank you so much, and I think we're wrapping up.
Thank you, Steve. Appreciate it.
Sure.